I don't understand that theory. You're going to end up in assuming litigation costs no matter what. The issue is which forum, in state or federal. Because in the federal forum, even if this claim is right, it's not a given that this subpoena violates your rights until a court determines whether there was reasonable cause for the Attorney General's subpoena, whether it was narrowly drawn. All the standards have to be met by the other side, but that's going to be litigated. So I don't understand how the burden of costs could ever be irreparable harm, but particularly in this situation where the cost is going to be incurred no matter what. So I think you have to rely on the chilling effect to your First Amendment rights. And if you don't rely on that, then every single case implicating an alleged constitutional violation like selective prosecution, vagueness, I could go on, all of those subpoenas will end up in federal court. And how do those people not make the same argument you're making?
So a few responses, Your Honor. First, irreparable injury is separate from the injury this court found in SBA list, which is the burdens of litigation. We don't need to show irreparable injury.
But answer my question. How is there a burden? You're going to litigate here in state court or federal court. Same questions. It's only an issue of who's going to answer them.
So I think that's not quite correct, Your Honor, for the reason being that if we're in state court, it's because we've been forced there because the Attorney General, as he has here, has enforced the subpoena.
But it's not as if you can go into state court and your motion in federal court removing and your action will be, has he issued the subpoena appropriately or not? If the federal court says it was appropriate, you'll still have to answer it. But somebody will have to litigate that question.
Yes, Your Honor, but I think the burden this court identified in SBA list is the burden of being forced into state court. If there's a credible threat—
I think the burden there was more the burden of the chill to First Amendment rights. The burden has always, in our cases, been the chilling effect, not the burden of litigation.
So we think, Your Honor, under SBA list, the best reading of that is that there are actually 4 possible imminent injuries. One is the burdens of litigation we've been discussing. One is the imminent disclosure order, in this case of donors. The third is the imminence of a adverse order on penalties. If you accept the AG's theory, maybe that doesn't exist in this case. And the fourth is the chilling injury.